Imagine opening your mailbox, and inside is a letter demanding payment. It looks official. The language sounds authoritative. Maybe it mentions attorneys, courts, government agencies, legal action, property, wages, or consequences for not paying. 15 U.S. Code Section 1692E establishes a broad rule. A debt collector may not use false, deceptive, or misleading representations or means when collecting a debt. The statute then gives specific examples of conduct that can violate it. The important point is that the statute isn't limited to one particular kind of deception. It establishes a broad prohibition, then provides specific examples. Number 1. A debt collector cannot falsely represent or imply that they're backed by, bonded by, or affiliated with the United States government or a state government. That includes using a badge, uniform, or something that looks like one. The issue is the false representation or implication of government affiliation. Number 2. A collector cannot falsely represent the character of the debt, the amount of the debt, or the legal status of the debt. That distinction is extremely important. Imagine someone tells you, you owe $10,000, but the actual amount is different, or they misrepresent what the obligation legally represents, or they claim a legal status that isn't accurate. The statute addresses false representations concerning the character, amount, or legal status of the debt. It also covers false representations about services performed or compensation that the collector may legally receive for collecting the debt. Number 3. A person cannot falsely represent or imply that they're an attorney, or that a communication came from an attorney when that isn't true. Why does that matter? Because the identity of the sender can dramatically affect how a person understands the seriousness and legal significance of a communication. A letter from a legitimate attorney and a letter merely designed to look like it came from one are not the same thing. Number 4. A collector cannot represent or imply that failing to pay will result in things such as arrest, imprisonment, seizure of property, garnishment, attachment, or sale of property or wages, unless the action is lawful and the collector or creditor actually intends to take it. That last part matters. The statute isn't saying lawful collection remedies can never be mentioned. It's addressing false or improper representations about what will happen. In other words, don't threaten consequences that aren't legally available or aren't actually intended. Number 5. A collector cannot threaten to take an action that cannot legally be taken or is not actually intended to be taken. This provision focuses on the difference between a legitimate statement about an intended lawful action and a threat designed simply to frighten someone into paying. The question becomes, is the threatened action legally available, and is it actually intended? Number 6. A collector cannot falsely represent or imply that selling, referring, or transferring an interest in a debt automatically causes the consumer to lose a claim or defense to payment. Think about that in everyday terms. A debt may change hands, a company may transfer an account, but that transfer itself cannot falsely be presented as automatically wiping away whatever claims or defenses the consumer may have. The statute also prohibits falsely implying that the transfer makes the consumer subject to practices prohibited by the FDCPA. A debt collector cannot falsely represent or imply that a consumer committed a crime or other disgraceful conduct in order to disgrace that consumer. In plain English, debt collection cannot become a weapon for humiliation through false accusations. Number 8. A collector cannot communicate or threaten to communicate credit information that it knows or should know is false. The statute also specifically addresses disputed debts. If a debt is disputed, the collector must not falsely communicate credit information while failing to indicate that the debt is disputed when the law requires that notation. This provision connects debt collection with something extremely important: the accuracy of information being communicated about a consumer's debt. Number 9. A collector cannot use or distribute a written communication that falsely appears to be authorized by a court, issued by a court, approved by a court, or authorized by a government official or agency. The same prohibition applies when the document creates a false impression about its source, authorization, or approval. Imagine receiving something that looks like a court document. Number 10. It prohibits using false representations or deceptive means to collect or attempt to collect a debt or obtain information concerning a consumer. The broader principle remains: deception cannot be used as the method of collection. Number 11. The statute establishes disclosure requirements for communications with consumers. Generally, the initial written communication must disclose that the debt collector is attempting to collect a debt, and that information obtained will be used for that purpose. There is an important statutory exception. This paragraph does not apply to a formal pleading made in connection with a legal action. So once again, context matters. Number 12. A collector cannot falsely represent or imply that accounts have been turned over to innocent purchasers for value. The key word is false. The statute is concerned with creating a misleading impression about what happened to the account and who acquired it. Number 13. A debt collector cannot falsely represent or imply that documents are legal process. A document can look official, contain legal terminology, or use intimidating formatting without actually being legal process. The statute prohibits falsely representing it as such. Number 14. A debt collector cannot use the name of a business, company, or organization other than its true name when collecting a debt. Identity matters. Number 15. If someone falsely tells you, "Nothing needs to be done," when the document actually requires action, that could create a serious problem. The law therefore addresses deceptive representations about the legal significance of documents. Number 16. Finally, the statute prohibits falsely representing or implying that a debt collector operates or is employed by a consumer reporting agency as defined by federal law. Section 1692E isn't simply about one particular sentence in one particular collection letter. Debt collection must not be accomplished through false, deceptive, or misleading representations or means. But there's an important legal distinction. Section 1692E applies to debt collectors covered by the FDCPA. Whether the FDCPA applies depends on the circumstances and the statutory definitions and exceptions. So when you receive a collection communication, don't look only at the amount demanded. Look at the representations being made. Who is contacting you? How are they identifying themselves? What are they claiming about the debt? What are they saying will happen if you don't pay? Are they claiming an attorney is involved? Are they implying government authority? Are they presenting something as a court document? Are they reporting information that is inaccurate? Are they correctly identifying the communication as coming from a debt collector? And most importantly, can the representations being made be supported by the actual facts and law?